Welcome to Reunion Weekend 2026. I'm sorry I can't be there with you. I would be there with you except for one pleasant obligation that preempts my appearance, and that is the fifth birthday party of my granddaughter. So you can understand where that takes precedence over Reunion Weekend, which would be number two in the hierarchy of desirable activities this weekend. But I am with you anyway via this video, and also via this video you get CLE credit in legal ethics. So let's begin. It's no secret. Apparently, it is a secret. It's no secret that one of the strategies of the Trump administration is to free itself of what used to be called, in an earlier time, checks and balances, to get rid of the checks and therefore the balances. And it does this in a number of ways. It gets rid of the commissioners of independent agencies. It gets rid of persons within the executive branch who it deems disloyal, according to some standard it has. It attacks the media. The media are a check. They're not a governmental check, but they are a check. The press is recognized as the only private institution in the United States Constitution. So it demeans the press. It demeans their questions. It beats up on reporters who Trump doesn't like, especially women. All these ways and other ways, it goes after the checks and balances. Congress, of course, is not there. It's out to lunch, permanently out to lunch. Trump threatens to primary any Republican congressperson who disagrees with him or challenges him, even modestly. So the Congress is not a check. And now we come to the judiciary and the law, and that's what I want to talk about. The law, through judges, through members of the bar, through state courts, are a check. Not often recognized as such, not as prominent a check as Congress perhaps, but a check. And what has Trump done to weaken, if not eliminate, that check? And I'm going to start with judges. In a remarkable statement, the Deputy Attorney General, Todd Blanche, a New York lawyer, in a speech to the Federalist Society last November, describing Trump's attitude towards the judiciary, the federal judiciary, said, quote, "It's a war, man. It's a war, man." This is what the Deputy Attorney General said to describe how the executive branch views its relationship to Article 3 judges. It's a war, man, the number 2 DOJ lawyer. It continues. A couple of months later, a Trump Justice Department official began to solicit examples of perceived judicial activism from all U.S. attorneys' offices to inform potential impeachment referrals to Congress. We've got a file on you, is what DOJ is saying. We're collecting stuff, and it may be used to file articles of impeachment. Now, we know that federal judges are pretty immune to this sort of thing. Impeachment requires a 2/3 vote of the Senate and a majority of the House, and probably the DOJ can get neither. But just that threat, even the possibility of a vote of impeachment in the House, with the trouble it creates for the judge, the need to hire a lawyer, the need to interrupt the judge's official duties to respond in the Senate, can be terrifying. It certainly can cause you to think twice before you antagonize DOJ officials, even if you know you're not going to lose your job as a result. You can't lose your job given the numerical requirements for a conviction following an impeachment. But they've got a file on you. House Speaker Johnson supports impeachment of judges, ran a headline in Law 360 in January. So members of the second branch, or maybe the first branch, the Congress, is endorsing impeachment of judges. When you think about a Article III judge, circuit judge, a district judge, they have nice jobs, they have nice incomes, but they don't need the trouble. And the Trump administration knows that. On the other hand, some are willing to put their objections to the behavior of DOJ in their opinions when ruling on a motion, say. They have to write an opinion, and they are willing to use that platform to respond to the attacks on the federal judiciary. So the New York Times reports that a nationwide review of dockets located 35 instances in which federal judges ordered the government or DOJ lawyers to explain why they should not be held in contempt for violating court orders. That's another way to avoid checks and balances. Just ignore court orders. What can happen to you? Right? Who's going to prosecute you for contempt? So judges grow angry over Trump administration violating their orders, was the headline of the New York Times in February. Judges struggle to signal alarm as fiery rulings become norm. So you can't say the judges are not speaking up, but they're speaking up in their opinions. And that may feel safe because they have to write opinions to explain their ruling. Then Trump comes in and starts calling a federal judge who ruled against the administration wacky, nasty, crooked, and totally out of control. Now, the fact that a judge disappoints you in her ruling is not a basis for criticizing the judge, let alone impeaching the judge, unless you're a Republican. If you are a Republican, it is a basis. So where are the judges? Beyond their statements and their rulings, where are the judges? I call this the silence of the judges. 2 days after Trump called out wacky federal judges, John Roberts at Rice University in a conversation on the stage at a forum in Rice University, warned that personal criticism of federal judges is dangerous and, quote, it's got to stop, close quote. Well, that's nice. That's like saying to your 5-year-old, be nice, play nice, no hitting. We need more from the Chief Justice. He could speak much more forcefully without risk of violating the code of conduct for the justices or without risk of having to recuse himself in a case. There's no question about that. Speaking in defense of the judiciary, responding to what the administration is doing, cannot possibly, if carefully phrased, in a dignified way, but emphatically and repeatedly wind up forcing a recusal. March 26, Bloomberg Law. President Trump publicly called on Republican lawmakers to pass legislation to rein in rogue judges and slammed jurists as criminals who hurt the country with their rulings. We got rogue judges that are criminals. They're criminals. What they do to our country, the decisions that they hand down and hurt our country. So he's not backing down, Trump. This is after John Roberts said what he said at Rice University. And then a couple of days later, 2 days later, Trump comes out and makes these statements. Meanwhile, threats against federal judges are increasing. Now, again, even if they do not fear harm, it's upsetting. And Trump knows that his attack on judges will increase the threats. And who knows from whom the threats will come. Threats against federal judges have heightened in recent years. Federal authorities logged 564 threats to federal judges last fiscal year, up from 509 the year before, according to data from the U.S. Marshal Service. This is from Bloomberg Law. So what we need is more vociferous condemnation of this behavior from the Chief Justice. He should not be shy. The little he's done is too little. We also can enjoy that kind of support from the Judicial Conference of the United States, which is a body composed of the Chief Justice, circuit judges, district judges. That body can also speak to what's going on, and forcefully. And there's no danger, again, of a recusal consequence to that kind of statement. The public will hear it. By contrast, if the judges say nothing, if we're left with the silence of the judges, the public will draw the wrong conclusion that from the judge's point of view, and they should know, there's no problem with the rule of law. It's just fine. The judges are not complaining, short of an offhand, casual, oral comment at a forum at Rice University. So judges have to step up to the podium repeatedly, not just once, in strong language, as a group or individually, and speak out. If you look at the Code of Conduct for U.S. judges available online, not only are judges allowed to speak publicly about the rule of law and threats to the rule of law, they are encouraged to do so. That is, it's not just that they may, they are encouraged to speak out. Again, failing to do so, the silence of the judges in that instance carries exactly the wrong message, a message they do not believe, but which their silence permits the public to infer. So that's the judges. And then there are lawyers. Since we're talking about checks, obviously the judiciary is a check. It's one of the three branches. It was envisioned as a check by the framers. But what about the lawyers? The lawyers, the government lawyers, the DOJ lawyers, aren't they a check also? Maybe not those who are politically loyal to the president, maybe not Todd Blanche, maybe not the Attorney General, whoever that may now be. They are politically chosen and they will be loyal to the president. If they can't be, they have to leave. But how about the line lawyers? How about the assistant U.S. attorneys who carry out the goals of the president and the Justice Department? Pam Bondi said that she takes her orders from the president. She's proud to take her orders from Donald Trump. That of course, crosses a line that we've always observed. Sometimes perhaps we have failed to do so, but dominantly we have observed that line, that division between the prosecutorial decisions of the Department of Justice on the one hand and the White House, even though the Department of Justice is a branch within the executive branch. It's an office within the executive branch. So when Trump says, as he has said, I can do whatever I want with the Department of Justice, in a way, literally, that's true, because it's his department. But we have maintained a division whereby the department makes its own decisions without influence or favor or interference from the executive branch. And DOJ lawyers should know that, although it's not by any means clear that they do know that. Now, here's what I have to say to the DOJ lawyers. But let's step back a couple of decades. We all know that Trump has repeatedly said, "Where's my Roy Cohn?" Roy Cohn was his lawyer in his early years. Anyone who has any doubt about the character of Roy Cohn, what a dangerous person he was, should watch the movie, the documentary, Where's My Roy Cohn? The title of the documentary is Trump's comments, Where's My Roy Cohn? It's a very good documentary that will tell you just what a miserable and dangerous person Roy Cohn was. This is the person Trump misses. You can get it on Prime. You might also, if you're historically motivated, you might also look at Point of Order, also a documentary. It's taken directly from the Army McCarthy hearings, where Roy Cohn was a junior lawyer to Senator McCarthy. This is Joseph McCarthy. And he's in that documentary. And there's a spillover effect from McCarthy to Cohn. You see the character of Cohn in the character of McCarthy. And then if you have any doubt left about Roy Cohn's character, you should read the disbarment order in 1986 from the First Department in New York, describing in some detail the effort Cohn made and how meticulous that effort was. It failed, as it turns out, to cheat his client of a lot of money. So that's the person that Trump idolizes as the kind of lawyer he wants. But it doesn't mean that he gets that kind of lawyer in DOJ. So the DOJ line lawyers have to worry about their reputation and about their licenses, because they can do things that wind up putting them in danger before the disciplinary committees and the courts in those jurisdictions in which they are licensed. They should understand this. They should understand that sometimes you just say no, and you have to be ready to quit. Many have quit, but others should be ready to quit if the instruction puts them in violation of the professional conduct rules, which are pretty demanding. So I say you can just say no. This is exactly what you say also to the military. You can refuse to follow an illegal order. And here's DC Rule 5.2, which says that subordinate lawyers are responsible for their conduct even if they are following the orders of a superior, unless that superior's resolution of a dispute, of an arguable question, is reasonable. You can defer to your superior if your superior's position is reasonable, but you cannot defend yourself by saying I was following orders. Otherwise, there is no following orders defense. DOJ lawyers should also know that they are responsible for the means by which a directive, an objective, is carried out. If the boss says, if the client says, and let's assume Trump is the client, he's not really the client, but let's for a moment assume he is, and he says, do this. Figuring out how to do this is up to the lawyer. The means is up to the lawyer. The end is up to the client. The rules are quite clear. I'm using the DC rules because there are so many DOJ lawyers in DC, but you get the same answer elsewhere. And so you lawyer, you DOJ lawyer, wherever you are responsible for how you do something, how you choose to effectuate the means, even assuming the end is legal. Big assumption, but assuming it's legal, You are responsible. You can say no. You can say, no, I will not carry out that order in that way, because the way is up to me. And I'm responsible for how I choose to do it. Now I come to decisions to indict. This is from D.C. D.C.'s rules on this are a little different from the ABA model rules. So the prosecutor in a criminal case shall not file in court or maintain a charge that the prosecutor knows, it's a high bar, knows is not supported by probable cause. Now, you might wonder, why would a prosecutor do that? The case won't go anywhere, but it causes a lot of pain to the person who's indicted. And so if the boss wants you to do that, if the boss wants you to indict someone against whom he seeks revenge, even if that case is ultimately going to be thrown out, it will cause a lot of financial anguish, financial pain and anguish to the person you've indicted. So a prosecutor who carries out that order in that way should know that he or she will have to answer for it if the record shows that there was no probable cause. And then there is paragraph C, which says even if you filed a complaint or got an indictment and it was supported by probable cause, as you continue to prepare for trial, you may come to know that the evidence is not sufficient to establish a prima facie showing of guilt, right? So there could be probable cause at the outset, but as more information is acquired, the information that will factor into the evidence introduced at trial, you begin to know, K-N-O-W, that a motion to dismiss this indictment at the end of the government's case will be granted because there is not prima facie showing of guilt. You know that. It's your job not to continue to prosecute that charge to trial, no matter what was the situation back at the beginning when you had probable cause to indict. There have been now, there are now, and will be more. I'll come back to that. There'll be more complaints filed with disciplinary committees about the behavior of DOJ lawyers. There was a very strong complaint filed against Pam Bondi in the Florida disciplinary machinery, but at the time, the court or the disciplinary committee, and the court, I think, refused to consider it because she was a sitting attorney general. And for some reason, that insulated her from a disciplinary prosecution. But she is no longer a sitting attorney general. In other words, no action was taken, but not because it would have been inappropriate on the merits. It was not taken because of her status, a status she no longer has. And so I have no doubt that the people who filed the Bondi complaints will be back before the Florida Disciplinary Committee filing the same complaint or maybe more complaints against her, and the status defense is no longer available to her. Rule 1.13a says when you represent an organization, you represent the organization, not its constituents. Applied to the federal government means the DOJ lawyers at any level, their client is the United States. Their client is not DOJ, it's not the Attorney General, it's not President Trump, it's the United States. And they have to keep their eye on that because it could be that a constituent's interests and the interests of the United States differ. And the loyalty obligation, the fiduciary obligation that a lawyer has to a client runs to the entity, in this instance, not to the other constituents of the entity. And so they have to ask themselves, am I being instructed to indict X for vindictive reasons? That's a question they have to ask. especially if there is no other reasonable explanation for the instruction, because you can't indict someone for vindictive motives. You can't indict somebody when a prosecution would be deemed selective. And so they need to ask themselves that question and refuse if they conclude either that it is illegal instruction or they need more information. They need to satisfy themselves, if they're in doubt, whether or not their concern is merited before they proceed. And there's a very nice New York City Bar Association opinion, 2025, restating much of what I just said, including the fact that a government lawyer may refuse orders from superiors that could, in the lawyer's independent judgment, result in a violation of the professional conduct rules. Emphasis on independent. A lawyer for any client is not a mouthpiece. It's not an automaton. You have a duty to exercise independent judgment. Both words are important, independent and judgment. And that's a non-delegable duty. You can't pass it off to somebody else. And if your independent judgment suggests or shows that the order may be a violation of law or cause you to violate ethics rules, you have to say no, or if you're unsure, investigate further so that you can satisfy yourself. A government lawyer, says the New York City Bar Association, who carries out a directive of a senior official, regardless of who that official is, that would violate the rules, may be professionally disciplined. So if a brand new DOJ lawyer in a prosecutorial office in a U.S. Attorney's office somewhere in the U.S. carries out the president's direction, he or she is professionally responsible for it if it was an illegal order or an order that violated the rights of the target, and can be professionally disciplined for it. They have to keep that in mind. You know, that's why I say to students, if you're going to work in-house, anywhere, make sure you know the quality of the person who is the general counsel. And make sure you know the fact that the C-suite personnel, CEO, CFO, etc., that they respect that person and abide by that person's conclusions about what the law allows or does not allow. Because you don't want the wrong people directing the operation of your general counsel's office. That can create a lot of angst and worry. So the general counsel has to be respected. And you might think about this if you're considering going to justice as an assistant. You might think about this in the context of the current administration. The opinion from the City Bar clarifies that a government lawyer who carries out a directive of a senior official, I think I said this already, regardless of who that official is, that would violate the rules, may be professionally disciplined. Okay. And then again, this is a remarkable opinion. I'm surprised the ABA hasn't written it also. All lawyers retain their personal discretion. This is like independent judgment as to how to achieve lawful objectives. That's the means-ends distinction. On the means, it's all you. You decide on the means, and you have personal discretion about how to carry out the client's objective. It is rare. In fact, until the Trump administration, and even until the second Trump administration, you didn't hear so much about vindictive and selective prosecutions. I mean, as an idea, it was present. As an idea, we understood that that's not good. But it didn't happen. But now there are allegations that it is happening, that there are revenge prosecutions. That Pam Bondi was fired because she couldn't get the revenge Trump wanted against certain defendants. He wanted a lawyer who can get that revenge. That's vindictive. That's selective. That indictment, if that can be proved, would be thrown out. There's no question but that. A vindictive and selective prosecution, if the proof can be made, will be tossed out. Whether or not Bondi's successor is more successful, or whether no one can do it because the evidence is not there, or if the evidence is there, it's clear that the case is being handled differently from all other cases on similar facts, we'll find out. We may find out. This is an example of the elements of vindictive and selective prosecution, and there's the citation on the screen should you happen to have an opportunity to investigate. The last check was the conscience. I can't stress this enough how important it is. The conscience of the government lawyer. Trump can't achieve anything at all from a law point of view without lawyers. You can't do it without lawyers. You can't run the United States without lawyers. You can't indict somebody and try somebody without lawyers. You can't subpoena somebody to a grand jury without lawyers. Whatever Trump does, he has to do through lawyers, and the lawyers' conscience, the consciences of the DOJ lawyers, although not recognized in the Constitution as such, is a check on executive branch abuse of power. And DOJ lawyers should understand that and should stand up to anyone who instructs them to misbehave. I realize there are pressures, and I realize there are financial needs, and I realize that it may not be so easy to get another job, but sometimes you just have to say no. Your oath requires you to say no, but decency requires you to say no as well. So now we come to another check, which we wouldn't have thought of as a check, because we would have thought that checks come from within the federal government, one of the branches, or by the media that Trump disparages. But now we discover that Trump identifies, or at least his Department of Justice identifies, the state court disciplinary apparatus as a danger to his targets, to his goals. He wants to preempt state court disciplinary committees. He wants to sideline them. And there's a, in your materials, there's a CFR provision floated a month ago with a 30-day notice period. And the 30 days ran out, I think, yesterday. And the CR provision, it's not well written, and I think that's intentional, actually. But what it certainly does, no question about it, this part is well written. If there is a complaint against a federal judge, a federal prosecutor, a federal lawyer, in fact, then DOJ has to be told about that complaint. And DOJ could choose to be the primary, or at least the first, investigator of the facts asserted in the complaint. So if there's a complaint against Pam Bondi filed in the Florida bar, then DOJ is the first to investigate the allegations of fact in the complaint filed with the Florida bar. And the CFR provision says, and the state disciplinary apparatus should stand down, should stand back while DOJ does this. It doesn't say how long it has to do it, but it gets the first crack at investigating it. If it decides the complaint is well merited, then it may go back to the state disciplinary system for the appropriate discipline of the Florida lawyer for that lawyer's behavior in DOJ, right? So the state apparatus then gets the complaint back again, but only after DOJ decides that, yes, there's some merit to the complaint, that the lawyer violated the applicable disciplinary rules. There's some merit. Here's where it gets vague, and I'll tell you how I read it. If the state bar decides not to stand down, it says DOJ will go into court to force it to do so. It can't force it to do so on its own, but it will go into court, presumably federal court, maybe federal and state court, to force the state disciplinary machinery to stand down until it gets the chance to investigate the facts. Now, if it decides after investigating the facts, whether because the state bar lets it go first or some court orders it to let the federal court to go first, and the federal court and the DOJ decides that there is no violation, then what? And here is where the CFR provision is vague. I read it to say that the DOJ authorities can dismiss the complaint. It certainly does not say clearly that the Florida or state bar committees, I'm using Florida as an example, can proceed with the complaint even after DOJ has decided that there's no merit to the complaint. So I think the idea behind this on the part of DOJ is that if we decide there's no merit, we dismiss the complaint, and if the state bar wants to proceed with it anyway, we go to court and stop it from doing so. And maybe we use the supremacy clause or something else to achieve that goal. Now, these CFR provisions were floated a month ago, and there was a lot of news stories about it. Even the mainstream press had a story about it, because suddenly the check of state bar discipline is in jeopardy. At least we had that check, state court discipline, for misconduct by state licensed lawyers acting in a federal capacity. So we have all the comments. This CFR provision is not final. There's a comment period ended 2 days ago, yesterday, and we'll find out what DOJ is going to do. I assume they're going to issue their rules as written and floated a month ago, that whatever comments they received opposing the rules are going to be ignored. And there's a history here, and I'm glad I have time to provide you with this history. Many years ago, in a case you may remember from your legal ethics class, United States versus Hamad in the Second Circuit, the circuit said that federal lawyers investigating a federal crime are governed by the state ethics rules that are present everywhere, that forbid a lawyer to talk to another lawyer's client on the subject of the first lawyer's representation. So if you represent Jack and my client is Jill, you can't talk to Jill, on the subject of your representation of Jack and my representation of Jill. Okay, the no contact rule, it's called. So the Second Circuit said, well, that rule also applies to federal lawyers who are investigating crimes, who know that the target of their investigation has a lawyer in the matter. They've been informed, hey, lawyer from DOJ, I represent Jill. Well, the Attorney General, who was Dick Thornburgh at the time, didn't like this, nor did his successor, Attorney General Janet Reno. And so what they did was they adopted a rule within DOJ that said that federal lawyers, notwithstanding the Second Circuit's decision, can do what these lawyers were doing and can ignore the no contact rule of the state court in the state that licensed the lawyer. The Eighth Circuit said that effort fails because the DOJ had no authority to create an exception to the no contact rule in its own internal regulations. So the DOJ escape hatch was rejected. And then the federal government indicted Congressman Joseph McDade. And he was acquitted. He did not like how the DOJ lawyers behaved. And he thought that more control over the ethics of federal lawyers were required to prevent a recurrence of the kind of behavior he saw in his own case. And when he got back to Congress after he was acquitted, he submitted what has become known, of course, as the McDade Amendment. And it's in your materials. I won't quote it because we don't. It's on the screen, 530B of Title 28. Maybe we do have it. Yeah, there it is. Look at that. And the McDade Amendment says effectively, federal lawyers are governed to the same extent and in the same manner as other attorneys in the state in which they practice, which may be the state that licenses them, or it may be the state into which they're sent to do their lawyering, their federal lawyering. But the import was clear. You don't escape state discipline because you're a federal lawyer if you act in a way that violates the ethics rules of the state in which you're licensed or in which you are practicing on behalf of the federal government. And the Attorney General was directed to adopt rules. So the McDade Amendment, the focus of the McDade Amendment was to bring back the states, to reassert their dominance in the importance of state control of the behavior of lawyers they license or who appear in the state to practice in the state, whether or not they're licensed by that state, to reassert the power of federal courts to exercise disciplinary authority of those lawyers. It was a state-favoring rule. Statute, in fact. Congress passed the statute. This is legislatively mandated. So any fair look at this would lead you to say, well, that was an intention intended to assert state primacy over federal discipline. And somehow, because they're very clever, whoever wrote the CFR position that was released last month turned that language into an authority for the federal government to take over and investigate complaints against federal lawyers licensed by a state. That what the McDade Amendment intended, state primacy without exception, actually authorizes the federal government to displace the state as the most important participant in the investigation of federal lawyer disciplinary behavior. Now, why is this important to the federal government? Because as the narrative leading up to the language that the DOJ proposed, it says, quite understandably, hey, there are all these complaints against our federal lawyers and it's interfering with our job to get the bad guys because it focuses their attention on other things and they're preoccupied and we have to figure out a way to sideline the states. These are my words. We have to find a way to sideline the states so any complaint against a federal lawyer that may go to a state disciplinary committee, which means a court, understand that it is the court in the state that is responsible for the enforcement of the disciplinary rules in that state. we want to ensure that our lawyers are not preoccupied with the multiplicity of complaints filed against federal lawyers that has somehow interfered with our federal function by taking away the investigative and maybe the final decision-making authority from the state disciplinary court, unless we are willing to let it continue with the discipline. That's what it turns it on its head. It's pretty brave, but it's not what the McDade Amendment was ever understood to do. What it was understood to do was exactly the opposite from what the CFR provision, which pretty soon, probably in identical form or close to that, will be effective. So those are the ways in which the Trump administration is neutralizing legal institutions to do what it wants, basically. I mean, it's obvious that Trump thinks he should be able to do what he wants. So the check of federal lawyers who are traditionally chosen based on merit, not on politics, the other ways in which the attacks on judges, that the federal government is interfering with the independence of the rule of law, undermining the rule of law. I'm not sure which is worse. You know, they're all bad. I think we're going to see more. We may actually see at least one impeachment vote. Because if you can do one, whatever happens to it, it's going to scare everybody. Impeachment of a judge. So I think that's it for me. But let me just make sure I've covered everything. Protecting the AUSAs, instructing the AUSAs that they can just say no, protecting the judges. The most important thing right now, I think, is for the federal judges to speak up, the Judicial Conference, and the Chief Justice. Okay, have a good time at your reunion and come back again next year when I hope I won't have a birthday party that will preempt my attendance.